Okay, cool. We are on. Hi, Tumelo. I've got Tumelo Mashabela. It's Mashabela IP, right?
Yeah, it's a long story. It's Mashabela Attorneys,
I want
but I
you to
also know as Mashabela IP. So
yeah,
I guess same WhatsApp group.
same WhatsApp group.
Yeah.
Cool. Thanks for joining me for our chat today. I think for the benefit of our viewers, our listeners, can you please tell us what you do? Obviously, your name, law firm, and what's your area of expertise?
Okay, as you said, my name is Tumelo Mashabela. I'm a director of Mashabela Attorneys. We are a law firm specializing mainly in intellectual property and commercial law. So your patents, trademarks, designs, as well as all aspects of all commercial aspects of IP.
Okay.
We also do corporate law as well.
Okay. Okay, cool. So for the sake of other people who might maybe muddle up certain categories within IP law, can you just remove the layers maybe in terms of the different categories, so that when we talk about a specific area of IP, people get a better understanding of what each is and what each one protects.
Okay. Most people know intellectual property, but intellectual property it's an umbrella term which refers to different types of intellectual property rights.
Yeah.
For example, we have trademarks. I like starting with trademarks because I think all of us can relate to that. I mean, I can see you're wearing a sweater with IBM. So trademark protects a brand, protects a slogan, like let's say IBM, a slogan can be, I'm loving it. It protects Nike, it can be the tick, can be the name Nike.
Okay.
So trademarks protects that kind of subject matters.
Yeah.
It so trademark basically it differentiates your goods and services from the goods and services of other people. That is why we are able to differentiate BMW versus Mercedes-Benz cars. So that's a trademark. That's a brand.
Okay.
I guess some of the well-known marks, would be your McDonald's, your KFC, your Microsoft, and and so on.
Okay.
And then we have what is called a design. A design protects the way something looks. For example, it will protect the shape of a chair, or of a cup, or of a bottle. So it protects a shape or a pattern of an article. And then the other type of IP right is a patent, which is mainly confused with a design. You hear somebody saying, I would like to patent my design. But basically, a patent protects an underlying concept. It protects a system. It protects a solution, a technological solution. It protects a way a method of manufacture. If you bring it into, let's say, the COVID-19, a patent will protect maybe the vaccine, or it will protect a diagnostic kit, a testing kit that is used for the pandemic. And then we have other types of IP rights. For example, we'll have geographical indicators. This will be words like your champagne or Rooibos. Basically, they relate to they trying to tell us where a particular let's say a particular goods are coming from. We know when you're referring to champagne, you will find them in France. So those are geographical indicators. Then we also have what you call plant breeders' rights. Plant breeders' rights will protect a new plant variety. For example, let's say you are now coming up with a new variety of avocados or apples. Those will be protected by plant breeders' rights. Yeah, so those are just some of the intellectual property rights that are available. Yeah.
Okay, so I've definitely learned something new. It's the first time I'm hearing about plant breeders' rights as well as geographic indicators. Quite interesting. I just want to take you back to, because you triggered something when you were talking about the design one. So design, would someone who, let's say, is a fashion designer and comes up with a pattern for like an Ndebele thing, like some nice artistic thing, right? Does that fall under the category of design?
It will fall under a design. For example, I'm going to give an example of, we all know Makosa.
Yes.
The pattern that they would come up with, as long as it can be industrially produced, it will fall under a design registration.
Okay.
Their particular new pattern. Yes. So indeed, fashion designers could obtain a protection through design registration. And design registration, it's one of those protection that a lot of people overlook, but it is, I think it's one of the important, it can be important for your business. And I think it's relatively cheap to obtain, and it's relatively easy to also obtain.
Yeah.
And even the requirements for it are actually, one is able to overcome or fulfill the requirements in comparison to a patent. Yeah.
Okay, quite interesting. Okay, and then so you touched a bit on COVID while you were talking. I think you were mentioning I think it was in the context of the patent around vaccines. So during this period that we are going through, COVID-19, and we don't know how long it's going to last, excuse me, what should an entrepreneur be aware of from an IP law perspective?
Okay, maybe I should just take you back to what has the government, what mechanisms or measures have been put in place
Yeah.
by our government in relation to responding to the national lockdown. So obviously, we are here within the lockdown. What happened is that CIPC, which is responsible for the registration of intellectual property rights, they issued a notice, and one of the things that they've included in their notice was that they are actually going to close the CIPC to the public from the 25th of March until the 30th of April.
Okay.
So you will note that the lockdown for CIPC actually started way before the national lockdown.
Okay.
And also, it actually also goes beyond the national lockdown, which we're all hoping that it will end by the 16th of April.
Yeah.
However, CIPC is extended to the 30th of April. So this means that one is not able to file any of these IP rights.
Okay.
So what they did is that the days 25th of March to the 30th of April, they've regarded those days as what is called dies non. Dies non, it's just a Latin name, which meaning that no legal business can be done during those particular days.
Oh.
So this means that if, for example, if you have filed, let me say, a provisional patent application, and as most of the people may know, once you have filed a provisional patent application, you have to file what is called a complete patent application within 12 months of filing the provisional application. So if your deadline of filing the complete application falls within the 25th of March and the 30th of April, you can't file. Your new deadline is going to be the 1st of May.
Okay.
Another thing, if, for example, as most of you may know, in order for you to continue to have your patent or your trademark, you're supposed to continually every year pay renewal fees. If
Mhm.
the deadline of paying your renewal fees falls within the 25th of March and the 30th of April, your
Yes.
new deadline is the 1st of May. So all the deadlines that were due between the 25th of March
Yeah.
until the 30th of April have now been moved to the 1st of May. So this is very important that anybody who had a deadline in relation to IP must ensure that they meet that particular deadline and file or respond to whatever that the CIPC requested by the 1st of May. However,
Okay.
the second implication of this lockdown is that we are not able to file any patent or trademark or design during this period.
Yeah.
So the CIPC, they have shut down all CIPC IP related systems. I'm not talking about company registration, and people need to be clear, because
Yeah.
company registration, it is systems that are operational at limited level. This is mainly for IP. So that IP system has been shut down. So you can't file any patent or trademark or design between 25 March and 30th of April. This is very important because there could be some entrepreneurs which are busy with their research, or they're busy with their innovation, or they're busy with whatever technologies that they're starting to create. And you know what? During chaos, actually, that's when people are coming up with solution. And
Sure.
we have seen in a lot of countries where, especially in China, where quite a number of solutions have emerged during this lockdown period. So unfortunately, if there is an entrepreneur or a company that is currently busy with that, they will not be able to file a patent application and obtain protection for their invention until the 1st of May. So remember, in order for you to file a patent, your invention should not have been disclosed to anyone in the public.
Okay.
So since you can't file until the 1st of May, it means that it is important for you to keep that solution secret until the 1st of May. So obviously, a lot of people may say, but Tumelo, I mean, how are we going to destroy the novelty? We are not meeting with anyone. We're not pitching to anyone. However, we are using online platforms. A lot of people, we could be sharing our solutions with potential investors through Zoom or whatever other platforms. So if you were to do that, you would have destroyed the novelty of your invention, meaning that you can't then on the 1st of May file your patent application. So it is very important for people to understand that disclosing or sharing your invention through online platforms will destroy the novelty of your invention, and you won't be able to file a patent application by the 1st of May.
Okay.
However, there could be other people who say, but Tumelo, unfortunately, with this investor, I really have to talk to them now, and because we are planning for post-lockdown. Post-lockdown, I want to manufacture these products. So in that instance, I would then advise an SME to say that then conclude what is called a non-disclosure agreement with whoever you're going to disclose the invention to. This will assist you in ensuring that the other party keeps the invention secret, and you are still then being afforded an opportunity to file a patent application by the 1st of May.
Okay.
And signing that non-disclosure agreement may also assist you so that the other party may not turn around and allege that they own that particular IP.
Yeah.
So non-disclosure agreements, obviously, I always say they keep an honest person honest. So they have their own limitations, which is just a discussion for another day. So another alternative could be that you could then file in other countries through their online systems.
Okay.
This will be suitable, for example, in this kind of scenario. Let's say Tumelo and Mzu are in the field of microbiology. We are all working towards trying to find solutions in relation to this pandemic. And obviously, we are different entities, but we are in the same field. So we are conducting R&D. So if it happens that Tumelo then goes and quickly files a patent application in, for example, through the UK filing system, unfortunately, you, Mzu, won't be able to then file a patent application since I would have filed first. So it's very important that as you are busy and depending on your business, you
Yeah.
might see the need to actually file through other countries' IP systems which are still active and operational, because you can't file in South Africa.
Okay.
So that could be an option. And believe you me, I've done a number of research. A lot of companies now are busy coming up with solutions, and they are filing. I mean, I was looking at China, the number of applications that they have filed in relation to COVID-19. You know, a lot of companies, a lot of countries, companies in different countries are filing patent applications relating to, one way or the other, some solution in relation to COVID-19. So what I'm trying to say is that as SMEs and entrepreneurs within South Africa, we shouldn't find ourselves disadvantaged with regard to IP rights. There are other options that we can look at in trying to ensure that we obtain IP rights even during the lockdown period.
Yes. So that comment brings me to this question in terms of the rationale behind why the DTI or the CIPC closed during this period. As you said, that this is the time when people are becoming more, solution-driven, ideas are coming up and all that, and we look at the international community, it's business as usual, as far as that is concerned. Do you perhaps know what the rationale was behind it?
One of the reasons that CIPC gave was that their IP system is not 100% an online system, so it
Oh, I
still
see.
require pardon.
No, I'm listening to you. So it requires
Yeah, so
human interaction.
yes, it still requires human interaction, and
Okay.
I guess because of that and the risk that they may have to put, the employees
Yeah.
during this period, that made them to make that decision. So you know what, it's a new period for all of us, and I don't think anyone has the right way of doing things.
Yeah.
And sometimes decisions had to be made, and maybe once they've been made, then that's when we actually realize that, oh, actually we should have decided other ways. But I
Yeah.
think from their side, they did whatever that they could or they thought was important or possible at that particular time. For example, the fact that they are allowing companies to still be able to register and obtain those permits for essential services. At the end of the day, that it takes me to that point where people are saying, but people are dying, this is the pandemic, why is IP important? But it is crucial.
Yeah.
IP is important. I mean, I'm going to share with you what the international community, what they are trying to do now. They're trying to call for what is called a COVID-19 pledge. And this pledge is being called it's been made by scientists and researchers and people in academia and IP attorneys, where they can see that in order for us to fight this pandemic, we still have to deal with IP issues.
Yeah.
So they are calling for owners of various patents in relation to coronavirus. As we know that coronavirus has been existing for quite some time.
Yeah.
So they're calling to say, if I own a patent relating to, let's say, either a diagnostic tool, I need to sort of sign a pledge and say, anybody who's going to use my patent during this period in an attempt to come up with a solution to fight the pandemic, I won't press patent infringement. I want to institute patent infringement proceedings against a particular person.
Yeah.
So it also illustrates that IP is important, because
Yeah.
some solutions may not be found because Tumelo has a patent and she's looking for royalties in order for you to use that patent. So it is a difficult time, because yes, obviously your patent, you created it or you obtain it for monetary reasons. However, now it's a time where as patent owners are supposed to be coming together and allowing each other to tap on each other's spheres in order to fight this pandemic. I mean, I was reading somewhere about in Italy where they had a shortage of ventilators, and SME was able to come up with valves through 3D printing. These valves are required for the ventilators, and then the owner of the ventilator or patent relating to the valves, raised an issue to say, but you're infringing our patent. But I understand eventually they were able to come up with a better solution so that they don't institute patent infringement. So IP is crucial at this time. And although, yes, at the end, we want you, once you have your patent, to share the solution, but also it is important to obtain protection because, I mean, from what I understand, this pledge is basically going to grant everyone, let me say, a non-exclusive license, royalty-free worldwide, in order to use my patent, in order to find a way to come up with a solution relating to COVID-19. However, post that, as a patent owner, I will then be able to either obtain royalties in relation to my patent. So filing your patent or obtaining protection is still important even during this time, even if subsequent to that you're going to allow people to benefit from it for social for social reasons.
As you have got a guest here.
Innovating. I mean, we've seen Rolls-Royce, which is now making ventilators. We've seen Zara is now making hospital scraps. I think it's University of Stellenbosch, their food scientist department. They were able to come up with use bread crumbs and to make sanitizers. So people are innovating. Yes, we are in a bad period, but this is, and I was also reading somewhere where they were talking about that this is the time, and it has always been like this, that during a pandemic or a crisis, this is where some of the best innovative solutions are actually being created. So it is important for companies to consider the filing of patent application or protecting their IP. And I'm available if anyone wants to contact me to find out what it would be the best way in them either preserving novelty or filing a patent application. We can have that discussion. But I think intellectual property, we have all seen that it's a game changer. And at the end of the day, the lockdown will come to an end, and business will have to continue. And one can only hope that your IP will assist you in actually moving your company forward.
Sure. That's great, Tumelo. So if we will share your details, but maybe just also share them on the video if someone wants to get in touch with you. How do we find
you can get in touch with us. Our website is www.mashabelaip.co.za. My email address is Tumelo M for mother @mashabelaip.co.za. On Facebook, you will find us as Chaya Mashabela Attorneys. LinkedIn, we are also Chaya Mashabela Attorneys.
Can you spell
Chaya,
please?
Pardon?
Can you spell Chaya for us, please?
Oh, Chaya, yes. Chaya is TSHAYA, and Mashabela MASHABELA. Attorneys. Yeah.
Thank you very much for your time. This was very insightful, and I am quite sure that a lot of the viewers will find that very helpful indeed. I think let's just continue to also have more of these conversations.
Yeah. No, thanks for the opportunity.
Thank you, Tim.
Okay.
Thank you.
Bye.
Bye.